I'm Rebecca, your host of Crafting and Crime Daily, the show where I recap live trials so you have something to listen to while you're crafting.
All right, Sheriff, please bring yours out. Thank you very much.
Please stand with yours. Okay. So you're going to go up to that last rope, let the sidewalk wall, and everybody else will come down that side. You go ahead and take your seat. There you go. What number? 15. Follow me. Y'all can spread out. Only 6 on the bench. If you can. You go ahead and take a seat. You may be seated.
Good morning to the full panel of jurors. We brought in two groups of jurors, and what we're going to start is the process of jury selection to get down between 12 and 14 jurors. Let me introduce myself. My name is Rebecca Robinson. I am one of the 5 jurors in the Newport News Circuit Court. I'm glad you all are here. Thank you for taking time out of your day today, your busy schedules. I hope parking wasn't too horrendous based upon the NoodleCon coming up this weekend, but welcome. Now, I want to just say we do have press coverage of this case, but I want to assure you, none of you all will be filmed. You are not permitted to be filmed by statute, and we've already confirmed that with the media. So I don't want you to have worry about any film coverage or media coverage that is not permitted of jurors or prospective jurors. So I'm going to turn it over to Madam Clerk. She's going to take roll and attendance and swear you in. We will not be using your names. We will ask you to use and identify yourself by your number. That's for your protection and it's part of best practices. So I don't want anybody to feel disrespected because I'm not referring to you by your names. I know you all have full names, but we can use numbers again for the press coverage and best practices for identifying potential jurors. Okay. Madam Clerk.
When I call your number, just say here, but make some kind of audible that you are here, okay? Number 1.
Here.
Number 2.
Here.
Number 3.
Here.
Number 4.
Here.
Number 5.
Here.
Number 6. Here. Number 7. Here. Number 8. Here. Number 9. Here. Number 10.
Here.
Number 11.
Here.
Number 12.
Here.
Number 13. Here. Number 14. Here. Number 15. Here. Number 16. Here. Number 17. Here. Number 18.
Here.
Number 19. Here. Number 20. Here. Number 21.
Here.
Number 22. Here. Number 23. Here. Number 24.
Here.
Number 25.
Here.
Number 26.
Here.
Number 27.
Here.
Number 28. Here. Number 29. Here. Number 30.
Here.
Number 31. Here. Number 32.
Here.
Number 33.
Here.
Number 34.
Here.
Number 35.
Here.
Number 36. Here. Number 37.
Here.
Number 38.
Here.
Number 39.
Here.
Number 40.
Here.
Number 41.
Here.
Number 42.
Here.
Number 43.
Here.
Number 44.
Here.
Number 45. Number 46. Number 47. Number 48.
Here.
Number 49.
Here.
Number 50.
Here.
Number 51.
Here.
Number 52.
Here.
Number 53.
Here.
Number 54.
Here.
Number 55.
Here.
Number 56.
Here.
Number 57.
Here.
Number 58.
Here.
Number 59.
Here.
Number 60.
Here.
Number 61.
Here.
Number 62.
Here.
Number 63.
Here.
Number 64.
Here.
Number 65.
Here.
Number 66.
Here.
Number 67.
Here.
Number 68.
Here.
Number 69.
Here.
Number 70.
Present.
Number 71.
Here.
Number 72.
Here.
Number 73.
Here.
Number 74.
Here.
Number 75.
Here.
Number 76.
Here.
Number 77.
Here.
Number 78.
Here.
Number 79.
Here.
80.
Here.
Number 81.
Here.
Number 82. Here. Number 83.
Here.
And number 84. Here. If I can have you all stand and raise your right hand. To each of you solemnly swear or affirm that your answers to such questions as may be propounded to you will be the truth, the whole truth, and nothing but the truth.
Yes.
Affirm. All right, you can have a seat.
I'm going to get started with my opening remarks, but I just wanted to let you all know, we will try to take frequent breaks, usually about every 60 to 90 minutes or so, to get water, to use the restroom, or if your knees are like mine, they just lock up and get stiff and you just need to stretch. So, but if anybody needs a break, just raise your hand and we'll do our best to accommodate you. All right. So members of the jury panel, the case for which you have been summoned to appear today as prospective jurors is that of the Commonwealth of Virginia versus Ebony Parker. She is charged with the commission that on or about January 6, 2024, did unlawfully in violation of 18.2-371B of the Code of Virginia 1950 as amended, did feloniously commit gross, wanton, and reckless care for a child, 8 counts of the same charge. Upon arraignment of the 8 charges, Ms. Parker has pled not guilty. The fact that she has been so charged by the Commonwealth and those indictments have been handed down and found against Ms. Parker does not constitute any evidence against the defendant and must not be permitted to influence the jury in any manner in arriving at a verdict. The making of a charge by the Commonwealth and the finding of indictments by the grand jury are simply part of the legal process necessary to commence proceedings by the Commonwealth against the defendant. It means nothing more than that. The defendant sits at counsel table before you, presumed to be innocent by law of the offenses with which she has been charged and for which she has been indicted. And this presumption of innocence goes with her throughout the case and applies at every stage throughout the trial. And it is sufficient to require the jury to find the defendant not guilty unless and until the Commonwealth, upon whom the burden rests, proves the defendant guilty to the said jury satisfaction beyond a reasonable doubt. Failing to do so, the jury should find the defendant not guilty. Furthermore, the defendant, Ms. Parker, does not have to testify during the trial of the case or offer any evidence, and this failure to do so cannot be considered by the jury in arriving at the jury verdict. The first thing we need to do is select a jury. In this type of case, we need a jury consisting of 12 jurors with 2 alternates. And I just want to concur with counsel or confer that if we want 2 alternates, correct?
That's correct, Your Honor.
Okay, thank you. We have a room of 84 people. We need to get 84 down to 14. We begin the process of determining who will be on the jury by asking questions. The court will ask you questions. The lawyers will also be given an opportunity to ask you questions. And asking these questions, we are not trying to embarrass anybody or unnecessarily pry into your personal lives. In addition, there are no right or wrong answers to our questions. We just need the truth. That's why you were asked to stand and take the oath that Madam Clerk administered. First, we must each be sure that you will give each party a fair and impartial trial based only on the law and evidence pertaining to the case. You will be asked questions designed to determine whether there are any reasons why you should not serve on this particular jury. If the court finds that it would be inappropriate for a particular juror to serve on this case for a specific reason, such as you're closely related to one of the parties, then that juror will be eliminated for consideration for service as a juror in cause. This is referred to as striking a juror for cause. If the court determines that one or more of you should not serve on this jury for cause, it does not mean that you did or said anything wrong. It does not mean that you are less qualified than anyone else. It simply means that in the court's opinion, circumstances exist that would make it inappropriate for you to serve on this particular case. After we have finished asking our questions and the court has excused those persons who the court feels should not serve on this jury for a particular reason, each party will be required to make peremptory strikes. Through the use of peremptory strikes, the parties use their discretion to strike or rather eliminate jurors from the jury panel until we get to the number of jurors we need for trial. The Constitution forbids making peremptory strikes on a discriminatory basis. Once again, please do not interpret the fact that you were not ultimately selected to serve on this jury as an indication that you are somehow unfit or less qualified than anyone else. Our system of selecting juries has been in place for many, many years. It works well, and it is the method that the courts and the parties are required to use. As I previously stated, but I want to reinforce Under state law, the media is prohibited from covering the jury or any jurors at any stage of these proceedings, including the jury selection process. Jurors' information is sealed and confidential in this case, except for the attorneys, and they cannot disseminate that information. So your information will not be released. And for further proceedings, the court will not direct anybody to contact you. So if somebody contacts you and says, oh, the court told me to reach out to you, that is not accurate, that is not correct. And after you are released from this term, though, you may speak with anyone you wish. For me, no one from the press will call you and say that Judge Robinson said to ask you about this. It's not going to happen. But once this case is over and you finish your term, you are free to speak to whomever you want, including the press. So those are the rules. The trial of this case is expected to last no more than 4 days, is what I understand from the attorneys. And we are about to begin the process called voir dire. And I'm going to take a few minutes to explain to you what that's about. Again, the questions we're going to ask are being asked to select a jury that will be fair and impartial to both sides. Those are the key words, fair and impartial. If your personal beliefs, attitude, or past experience make it difficult for you to be dispassionate or difficult to follow the instructions of law given to you by the court, we're entitled to know that in advance. Again, there are no right or wrong answers. No matter what your answer might be, the only improper answer is an untruthful answer. If there's a question that the court or the attorneys ask that you believe is sensitive, and you would like to answer that question outside of the presence of the other jurors, please let us know by raising your hand, and we will make accommodation to do so. So what happens is if there's a question you want to answer privately or that we direct to be answered privately, we'll take a break and we'll go into the side room to have that be done out of the hearing of other jurors. Now, I'm going to start my questions, and I'll ask you the question and ask for the yeses and ask for the nos. Okay. First question is, are each of you 18 years of age or older?
Yes.
Is anyone under 18? Are each of you citizens of the United States?
Yes.
Is anyone not a citizen of the United States? Have each of you been a resident of Virginia for at least 1 year prior to being summoned to this jury?
Yes.
Has anyone not been a resident of Virginia for 1 year? Have each of you been a resident of the city of Newport News for at least 6 months prior to being summoned on this jury?
Yes.
Has anyone not been a resident of Newport News for at least 6 months? Have any of you all been convicted of a felony and not had your rights restored to you?
No.
Have any of you all been convicted of treason?
No.
Are each of you proficient in the English language?
Yes.
Is there anyone who feels that they're uncomfortable with the English language? Okay, and I see that's number 19. Okay, stand up for me, please. Don't give me your name. I see juror number 19. Yes, ma'am. What's your preferred language?
Spanish.
Okay, and how comfortable are you with the English language?
I'm comfortable to carry a conversation on a regular day basis, but I'm very unfamiliar with some terms in English that I'd be like, what does that mean?
All right, thank you. I've noted that. Thank you. You may have a seat. Anyone else? All right, this is a worded question. Have any of you been called and reported to any state court for either civil or criminal jury at any time during the prior 3 years prior to being summoned to serve on this jury? So has anyone served in the jury in the past 3 years?
No.
Okay, by law, we try to give you a 3-year break between being called for terms, okay? Have any of you been adjudicated as incapacitated by any court?
No.
Do any of you have a case pending in the current term of this court that is expected to be tried by a jury?
No.
Were any of you present when the grand jury was instructed on the first day of the term during which these indictments were handed down?
No.
Do any of you have a hearing impairment not corrected by hearing aids?
No.
Okay, I'm gonna go a step further. Is everyone able to hear me?
Yes.
Is there anyone who's having any trouble hearing me?
No.
And as we go on throughout the proceedings, because different people will speak from different points in the courtroom, if you have a hearing issue, let us know and we'll do our best to fix it. Do any of you all have a sight impairment, a vision impairment, which is not corrected by lenses?
No.
Does anyone have any medical condition that would prevent them from sitting on this jury?
No.
Okay, yes, ma'am. Give me your number, please. 15. Are you able to stand?
Yes.
Please do. Okay. And is it something that you're okay stating publicly?
No.
Or do you want to answer privately?
Yes.
Okay, we'll mark you down and we'll take you down. You can have a seat. Thank you. Again, as I mentioned earlier, the trial of this case is expected to take 4 days. Do any of you have pressing business that will prevent you from giving your full attention to this case for 4 days? Okay.
Yes.
Number 11. I can see you, number 11. Anybody else? Okay, hold on. We've got number 11, number 73. I looked for my glasses today, and who knows where they are, but I'll try to have them tomorrow. Okay, 73 and 75 and 34, and I'm going to get back to you. I'm just marking it in, and 47. Okay, and I got you 73. Okay, thank you. Okay, we'll start with juror number 11. Yes, sir. And you stand, please.
I have religious observance on Friday, it's a holiday. for my
Okay.
week. I've already notified the court and received permission to be excused on that day.
All right, thank you, sir. Okay, and number 34, juror number 34. Yes, sir.
I have a graduation I'm going to, on the 28th.
28th of this month?
Yeah, man.
Okay, thank you. All right, and juror number 47.
I'm also caretaker for my father who has Alzheimer's and dementia. I take care of him every day.
Okay, thank you very much. All right, juror number 73.
My family has reservations to go out of town on Friday for the holiday.
Thank you. And juror number 75.
Yes, ma'am. I've been summoned as a witness for another court case on the 20th, and on the 25th, I gotta go to a music festival.
Okay, so you're summoned as a witness in another court case, on the 20th, so that's Wednesday of this week.
Yes, ma'am.
Okay, and where is that? I mean, like what city? Here in the Queens. Okay, thank you. Okay, is there anybody else who wanted to give an answer to that question that I did not call? Okay. Okay. And Ms. Parker, if you please stand, I'm gonna ask if anybody's related to you. Okay. All right, Ms. Parker is the defendant in this case. Are any of you related by blood or marriage to Ms. Parker?
No.
All right, does anyone know Ms. Parker?
No.
Okay, thank you, Nancy. And Commonwealth asked somebody, oh, you do, okay, number 70. Okay, stand up, thank you for me, if you can stand, please. Okay, yes, ma'am.
She's in my sorority.
Okay. mark that down. Thank you very much. All right, and any numbers that I may have missed on that question of related by blood of marriage or no, Ms. Parker? All right, no additional answers. The Commonwealth will ask you about their witnesses. Have any of you had any business dealings or an employee-employer relationship with Ms. Parker?
No.
Do any of you have any interest at all in the trial or outcome of this case?
No.
Have any of you, yes, oh, we have, okay, juror number 79, thank you. Okay, to which question? Okay, business dealings?
No.
Oh, the interest in trial, oh, interest in the case. Okay, juror number 79, yes, ma'am.
Friends with the teacher that's involved.
Okay. Okay, thank you very much. Okay, and it's number 58. Please stand. Yes, ma'am.
Yes. I don't know if this is a conflict, but I believe I work for the same school district.
Okay, you work for the Newport News Public School Systems. Okay, thank you. All right, and, okay, number 8. Yes, ma'am.
If that is a conflict, I also work for the same school district.
Okay. Thank you. And anyone else? Okay. Hold on, I saw a hand raised, but not a number. In the pink shirt, ma'am, in the pink, you didn't, okay, not you.
There's two back here.
Okay, thank you. Let me know. 61. Yes, ma'am.
I'm married to someone who works in the administration for news.
Okay. Thank you. All right, and there was one more number, and that's 59. Yes, please.
My daughter-in-law is principal in Newport News and went to that school the following year after this incident occurred.
Thank you very much, juror number 59. Okay, I saw number 20. I'll get back with you. Let me record her response. Okay, juror number 20. Yes, ma'am.
I don't know if it matters, but I'm a teacher for Newport News School.
Thank you very much. All right. I have another, okay, 69. Thank you, juror number 69. Yes, ma'am.
It does affect it. My sister who I live with is a teacher in the district.
Okay, and your sister? Okay, thank you. Okay, I'm coming. Number 70, 74 and you're number 17? Okay, yes, ma'am.
Sister also works for Newport News.
Okay. And you're number 74?
My aunt works for Newport News District for
Okay.
schools.
Okay, thank you. And I'm sure the attorneys will have some follow-up questions, so I'll take, we have 80 and 77. So let me start with 80. Yes, ma'am.
My aunt is a Newport News teacher.
Okay, thank you. And 77, juror number 77.
My mother's an employee for the Newport News School District as well.
Okay, thank you. Any other numbers? All right. Have any of you expressed or formed any opinion as to the guilt or innocence of the defendant, Ms. Parker?
No.
The Commonwealth today is being represented by attorney Joshua Jenkins or Josh Jenkins? What's your preferred?
Josh Jenkins.
Josh Jenkins. And he's presenting himself to you. And then thank you, Mr. Jenkins. And then the defendant is being represented by Mr. Curtis Rogers and Mr. Stephen T. All right, thank you, gentlemen. You can have a seat. Have any of you been represented by the attorney who represents the Commonwealth? So the first gentleman who stood, have any of you all been represented by him?
No.
Have any of you been represented by the attorneys for the defendant, Mr. Rogers and Mr. T?
No.
Okay, but I have a number. Yeah, give me a number. 17? Okay, yes. Who do you know? Who have you been represented by? Okay. Thank you. Can I have a seat? Anyone else who's been represented by the attorneys in this case? Mr. James, do you feel the need to list the attorneys that are in your office?
I can do that, Judge.
Okay, if you would, wish, please do so.
I'm going to read a list of names of attorneys, and at the end, I will simply ask you to show your number if you recognize any of the names. Anton Bell, Karen Rucker, Kate Buffington, Amanda Winchester, Pia Miller, Faith Laney, Emily Huff, Mackenzie Butler, Mary Button, Emma Cleary, Amy Cross, Angela Davis, Alberto Guerrero, Lynette Hill, Haley Lieberman, Rael McClure, Molly Newton, Jennifer Truitt, or Ryan Serby. Please raise your number if you recognize any of those names. And I'm saying if you go up.
Okay, and we're gonna go in order, so just hold it up till I get to you. I saw number 14, you're number 14. And which name did you recognize?
Mr. Bell.
Okay, and how, what's your connection to Mr. Bell?
I don't have one, I just know his name.
Okay, thank you. Okay, anyone else in this section right here? Okay, and I see you over there, I'm gonna go to this section to my right, your left. Kathy, number 49. Okay, juror 49, which name did you recognize?
Anton Bell, Karen Rucker, former paralegal for the Hampton Commonwealth Attorney's Office.
Okay, thank you, juror number 49. Okay, anyone else in the section to my right? Okay, now I'm gonna move to the section to my left, okay? Juror number 71, yes, sir.
Your Honor, I recognize the name Molly Newton,
Okay,
and I had served in public office, and Ms. Newton had come to my office to interview for a possible position on the bench.
okay, thank you, sir. Thank you, juror number 71. Okay, there was another number, 83, yes, juror number 83. Whom did you recognize?
I recognize Mary Button, but I'm not comfortable stating where I know her from.
Okay, thank you. Okay, any other numbers raised in the last section? Okay. And Mr. Rogers, Mr. Chief, do you wish to list any associates, and for the jurors today?
No, ma'am, I don't have any associates, but under the abundance of caution, should we have Mr. Jenkins list the names of the office that he previously worked in?
I'm not, Mr. James, is your response to that?
I think the whole point of being appointed as a specialist, that doesn't matter. But if you want me to read the names, I can.
I concur, right? I think Nancy, you've listed your office and Nancy, you come to attorney's office. All right. And Mr. Jenkins, do you have all of your witnesses here?
They're not here due to them being scheduled out, but I do have a list of the names.
Okay, so I'm gonna ask him to call the names of his witnesses to see if anyone recognizes them. Please do so, sir.
And Judge, correct me if I'm wrong, but I think we're looking for anyone who knows this person personally as opposed to just recognizes the name from a public statement.
Oh, yes, sir. So if you phrase your question that way, please.
Yes, so I'll read a list of names, and at the end, we'll ask you if you know or have interacted with this person personally. You may have recognized the name, but did you interact personally, will be the question. The names are as follows: Abigail Zwerner, Amy Kovac, Deputy Briggs of Newport News Sheriff's Department, Deputy Blythe of Newport News Sheriff's Department, Rihanna Foster, Mia Oliveria, Lawando Russ, Rolando Rawls, John Sims, Jennifer West, Susan White, Nina Farish, Jessica Steves, Megan DeLeon, Nicholas DeLeon, Mark Garcia, Tynesia Richardson, Alicia Thompson, Kelly Wells of NNPD, Newport News Police Department, Sean Amadeo of Newport News Police Department, Stacy Husterberg of Newport News Police Department, and Aaron Thornton of Newport News Police Department. Also Brittany Gregory, Ramon Gonzalez Hernandez, Sarah Gonzalez. So anyone who knows personally or spoken personally.
We have juror number 79. Okay, yes, juror number 79, and I know you did previously say you were friends with the teacher. Okay, all right, but no other persons. All right, thank you. All right, no other numbers presented for that response. Okay, and Mr. Rogers and Mr. T, do you have your witnesses here?
Your Honor, we don't have any additional witnesses other than those called by the Commonwealth.
Okay, all right, thank you very much. Okay, now I have a few questions that are going to instruct on what the law is and to assess your ability to follow that. Do each of you understand that the defendant is presumed by law to be innocent of the offenses for which she is charged, and that the presumption of innocence remains with the defendant throughout the trial?
Yes.
Are you able to follow that rule of law?
Yes.
Is there anyone who is not able to follow that rule of law? Do you understand that the law requires that the Commonwealth prove the defendant's guilt beyond a reasonable doubt?
Yes.
Are you able to follow that rule of law?
Yes.
Is there anyone who is not able to follow that rule of law? Do you understand that during the trial, the defendant is not required to testify or to produce any evidence?
Yes.
Are you able to follow that rule of law?
Yes.
Is there anyone not able to follow that rule of law? And like I said earlier, there are no right or wrong answers, we just want the truth. Do you understand that the defendant's election to not testify cannot be considered by the jury in arriving at a verdict?
Yes.
Are you able to follow that rule of law?
Yes.
Is there anyone who is not able to follow that rule of law? Do you know of any reason whatsoever why you are unable to give a fair and impartial trial to the Commonwealth of Virginia and to the defendant Ebony Parker, based solely on the law and evidence? Okay, I have two numbers, 22 and, 68. Is that 68? And 80. Okay, we'll start with 22. Yes.
I've been following social media of the case.
Okay, don't tell me what you saw on it, but that's influenced you.
I believe that the media has been in one particular life.
Okay, hold on, okay. And we're gonna get to the media questions too, but thank you. I'm gonna go on it first order and then I'm gonna come back around. So what is this? Clockwise. Okay, so juror number 68. Yes, what's your concern?
I have personal feelings for this that I think would influence my answers towards them.
Okay, and don't tell me what those are, but we may follow up privately. Thank you for letting me know.
Judge, what number was the most recent?
68. Sir, you were 68, I want to confirm?
Yes, ma'am.
Thank you.
Thank you.
And I believe juror number 80? Okay, yes, ma'am.
I personally feel like I'm too biased to be on the stand for this case. I work at the hospital, so I see situations like this all the time.
Okay,
So I think it's a personal matter that I can't do.
thank you.
Thank you.
Okay, now I saw there were some other people who did answer with their number that they had concerns if they could give a fair and impartial trial. And so I'm going to start back around. In the, those in the jury box, number 6. Okay, and what are your concerns, or what's the basis for your concerns without giving me too much information?
Well, I have personal concerns about it because it's something happened to my son years ago, dealing with something like that.
Okay, okay, thank you. and then to the section to my right, juror number 16, yes, please.
My mother is a retired school principal, and most of my friends are teachers somewhere. And also, I am a big proponent for the Second Amendment.
All right, thank you. All right, in this section, and that's 58, yes, please.
I think I'm still conflicted where I am a current teacher in the school district.
Oh, thank you. All right, moving to the third section, juror number 79, yes.
Very biased, towards Miss, Abigail.
Okay, all right, thank you. Anyone else in that section? Okay, juror number 69, yes.
I just saw things on social media that made me biased.
Okay, so something you said, yeah, thank you for not telling me what, but something you saw in the media has persuaded you. Okay, thank you. Okay, any other numbers to that question? Okay, I'm circling back to juror number 13. Yes, please.
I'm familiar through social media with the trial. My husband and many family members are also teachers,
Okay,
and my children are in the district.
all right, thank you. Anyone else? And my last question, do any of you have any religious or other moral reservations about passing judgment on another person? Okay, juror number 22. Yes, if you could please stand up for me and tell me what those are.
I don't believe I should judge any person because I do never have all the information available. I believe it's Christ's king.
Okay, thank you. Any other numbers to that question? And let me see, so that's 12:06, we've been going about 40 minutes, we'll go a little bit more before we take a break. Does the Commonwealth have any relevant questions on what you?
We do. Reiterate what the judge said earlier. Thank you for doing this. I know it is an inconvenience and we all appreciate your service. I have a few questions. With this first question, I'm just going to ask you to raise your number if it's a yes. Have any of you served as a juror before in any trials? Just hold up your number if you have. I'm going to start here and I'll work my way up around the room. Who was in this box? Number 6, are you holding yours up? I can't.
No.
Okay, thank you. Number 11, you have served as a juror on another case?
40 years.
Okay, was it, if you remember, was it a criminal case or a civil case?
It was criminal.
Okay, and if you remember, did your jury reach a verdict of some kind? Okay, and do you believe that the outcome was fair under the circumstances of that process? Okay, thank you. Anyone else in the box served on a jury? Okay, we'll go to this side now. I see number 18. I'll start with you, sir. You have served on a jury?
Yes.
Okay, if you remember, was it a criminal or a civil case? Okay, and did your jury reach a verdict of some kind? It doesn't matter to me what the verdict was. Did they reach a verdict?
Yes.
Okay, and do you believe overall that the verdict your jury reached was fair, whatever it was? Okay, thank you, sir. Who else in number 15? You have served as a juror before, ma'am?
Yes.
And was it a criminal case or a civil case? Criminal, is that right?
Yes.
And did it reach a verdict?
I wasn't there long enough to get.
Understand. Anything about that process that you thought was unfair for the part you were involved in? Okay, thank you. And that, yes, number 25, you served on a jury, was it criminal or civil? It was criminal. And did that jury reach a verdict? It doesn't matter what it was. Okay, and whatever it was, do you believe the outcome was fair under the circumstances of that case?
Yes, I do.
Okay, thank you. Anyone else right here? Moving back. The next one I see is 44, served on a jury then.
Yes, it was criminal.
Okay, and anything about going through that process and the mistrial that you thought was unfair? No. Okay. Looking for number 60 is the next one. I see you served on a jury.
Yes.
And a civil case. And did the civil jury reach a verdict?
Yes.
And do you think the process and the outcome was fair?
Yes.
Okay, thank you. Number 65, same questions to you, sir.
I was on a grand jury.
A grand jury. Okay, now the grand jury that you served on, did it have anything to do with the case for which you've all been brought here today? No? And how long ago was that?
7 years ago.
Okay. And was there anything about the process of serving on a grand jury that you thought was unfair? All right, thank you. Anyone else on this side that I missed? All right, thanks. Over here, number 71, you served as a juror.
Yes.
Was it criminal or civil?
Criminal.
And did the jury reach a verdict?
Yes.
Do you think the outcome was fair under the circumstances?
Yes.
All right. Number 70, you served.
Yes.
And was it criminal or civil?
Civil.
And did it reach a verdict?
Yes.
Did you think that the outcome was fair?
Yes.
Okay. Number 78, same questions.
Yes, and criminal, that they reached a plea deal before jury deliberation.
Okay. Anything about the process as it unfolded that you thought was unfair?
No.
Okay. Anyone else? Anyone I missed? Okay, thank you. The second question, if you need to answer the question privately, we will just write down your number and do that. If you're okay speaking about it, I'm going to ask only very limited follow-up questions about this. But the question is, have you or any member of your immediate family ever been accused of a crime? So immediate family means people that you live with or have lived with. And a crime does not include traffic matters like speeding or parking tickets or anything like that. So have you or any member of your family ever been accused of a crime? And then I'm going to preview, if you answer yes, I'm going to preview what the next couple of questions will be so you can decide whether you can answer publicly or not. I will ask you how long ago, in what city or state. I'll ask you whether a case went to court, and then I'll say, whatever the outcome was of the case, do you believe it was fair under the circumstances? And that's it. So I won't be asking you about the details of the accusation. If that makes sense, okay? So to the question, have you or any member of your immediate family ever been accused of a crime? I'll start here. Hold up your numbers, please. Number 9.
Yes.
If you're comfortable answering, how long ago was that?
About 22 years ago.
Was it you or a family member?
Me.
And what city or state?
Newport.
Did it go to court?
Yes.
And whatever the outcome was, it doesn't matter to me, but do you believe it was a fair outcome or not?
Yes.
Okay, thank you. Number 11, you or an immediate family member? Understood. And how long ago was that?
Within the past year.
And in what city?
Fort Collins, Colorado.
Okay, and did it go to court if you know?
They negotiated a plea.
Okay, and do you believe the outcome was fair under the circumstances? No. Okay, anyone else? All right, so on this side, number 16. Was it you or an immediate family member?
Immediate family member?
How long ago?
I'm not sure the exact timeline. I'm in the process of a divorce, and I found out after the date of the marriage that my husband had assaulted other women before me, and also been arrested for assaulting a neighbor.
Okay, thank you. Number 17, just was it your immediate family member? I know the answer. If you don't mind standing up, though, let me go ahead and ask you the questions for the record.
Well, there's
Okay?
another one too, so I'll talk
Okay.
privately.
Okay, so you were an immediate family member.
Immediate family.
And how long ago?
There was
Yes,
several
you can give me a couple, the most recent. How about that?
within the past couple of years.
Okay, was that in Newport News?
Yeah,
And did it go to court?
it did.
And do you think the outcome was fair under the circumstances?
Yeah.
Okay. You can have a seat. Thank you. Number 19. You were an immediate family member. Okay, and how long ago?
20 years.
20 years. Okay, what city or state? And did that actually go to court? And whatever the outcome was, did you think it was a fair outcome? Okay, thank you. Looking back, number 28. Was it you or an immediate family member, number 28?
Immediate family member.
Okay, if you can stand, that would be helpful for us all to hear you. And how long ago, roughly?
2 to 3 years ago.
Okay, what city and state is that?
Eastfield.
Thank you.
I'm
Did it
trying
go
to
to
hear her
court?
answer.
Oh, the court order needs her. She didn't hear you. Say it again, please.
Eastville, Virginia? Thank you.
Eastville, all right. And did it go to court?
Yes.
And whatever the outcome it was, do you believe it was fair under the circumstances?
Yes.
All right, thank you. And is that 29? You were an immediate family member.
Immediate.
All right, how long ago?
20 years.
20 years, all right. In what city or state?
Jared.
I couldn't hear that city.
Jared.
Jared?
Jared.
Oh,
J-A-R-R-A-T-T.
yes.
Jared,
Yes,
Virginia.
thank you. Did that go to court? And whatever the outcome was, do you think it was a fair outcome? Yes. Okay, thank you. Number 30?
Yes, was an immediate family member
Okay, and how long ago?
within the last year.
Okay, in what city or state?
Newport News.
Did it go to court?
Yes,
And do you believe the outcome was fair or unfair?
unfair.
Thank you. Number 21, was it you or an immediate family member?
So,
Okay, how long ago?
a couple times, most recent was, I think, within the past 10 years, 7 years.
Okay, what city or state? Oh, most recent.
Most recent was Newport News.
Okay, did the matter go to court?
It did.
And whatever the outcome was, do you think?
For the most recent one, I feel it was just, but.
Okay. Okay, and then of your other experiences, how many would you say were unjust?
Just probably one.
Okay, thank you, appreciate it.
Okay, Ms. James, I'm sorry, I didn't get the gentleman's number. What was your juror number?
21.
21, thank you.
All right, working my way back, number 34, was it you or an immediate family member?
Me,
Yeah.
myself,
You, okay, and how long ago?
36 years.
All right, in what city and state?
Newport News.
Did the matter go to court?
Yeah, but they got dropped. That's,
Okay, so I'm assuming you thought that outcome was fair.
yeah.
Okay, thank you. All right, anyone else? Number 37, I see it. Was it you or immediate family member? Sir?
It was me,
All right, and how long ago was that?
about 40 years.
40 years. And what city or state?
Newport.
Okay, did that go to court?
Yes.
And whatever the outcome was, do you think it was a fair outcome or no?
No, sir.
All right, thank you. I appreciate your honesty. Number 41, I see you. If you don't, if you could say that, makes it easier to hear. Was it you or an immediate family member? All right, and how long ago?
More than 20 years ago.
Okay, long time. So what city and state was that in? Essex, Virginia. And did it go to court?
Yes.
And whatever the outcome was, do you think it was a fair outcome? All right, thank you. All right, 45. You or an immediate family member? All right, how long ago?
13 years.
All right, what city and state?
Started from Southampton, Virginia, and then went to
Okay, Franklin and Southampton and then federal. Did it go to court federally? And if you know the outcome, do you believe it was a fair outcome? All right, thank you. That was no. The answer. Can I see your number again, please? 45. Thank you. All right. Number 50. Was it you or an immediate family member? Okay, could you stand sort of hard to hear? What city and state? And you said it was dismissed. I assume that you were okay with that outcome. Thank you. Looking number 68. Was it you or a member of your family? All right, and was it how long ago?
7 years.
All right, and what city and state?
Chesapeake, Virginia.
Did they go to court?
Yes.
And do you believe the outcome was fair under the circumstances? All right, and remind me of your number, I'm sorry.
68. I didn't hear the response. Fair or unfair?
Whether you thought it was fair or unfair?
It was fair. Okay, thank you.
All right, thank you, number 68. Anyone else from this side that I missed? All right, coming over here, number 73. That you or a member of your family knew. All right, and how long ago?
30 years ago.
City and state.
Newport News.
Did the matter go to court?
It did.
And did you believe the outcome was fair or unfair?
Fair.
Okay, thank you. Number 70. Was it you or an immediate member of your family?
Immediate family member,
Okay, how long ago?
5 years.
And what city and state?
Newport News,
And did it go to court?
yes,
And do you believe the outcome was fair or unfair?
yes, fair.
Fair, okay. Thank you. Number 79. You were an immediate family member. And how long ago was that? Okay, could you speak up just a little bit? I want to make sure the court reporter can hear you way up there. A year ago?
Yes.
All right, and what city and state?
Newport News.
Newport News, and did it go to court?
Yes.
And whatever the outcome was, did you think the outcome was fair?
Unfair.
Unfair, all right, thank you. Number 78. Was it you or an immediate family member?
I have 2 immediate family members. One was 40 years, one was 15.
Okay, in what cities or states?
One here in Newport News and one was federal. And they
Both had it, went to court. Okay, whatever the outcome was of each one, did you think that each one was fair or unfair?
Fair.
Both were fair?
Fair.
All right, thank you. Number 75. Was it you or an immediate family member? Okay, and how long ago was that?
Well, 30 or 40 years ago.
Oh,
Okay, speak up, I'm sorry, sir,
before
just speak up a little bit.
Sorry about that. Before I was born, about 30 to 40 years ago.
30 or 40 years ago. Okay. If you know, what city or state?
New York. I know it was in New York. I don't know what.
Okay. And if you know the outcome, do you have an opinion about whether the outcome was fair or unfair?
I feel like it's fair.
Fair, okay.
I don't really know.
So, okay, sure, understood. It was before you were born. Okay, 84. So you were an immediate family member.
Immediate family member.
And how long ago?
I want to say about 7 years ago.
Okay, and what city, state?
I believe it was on a military base. I think it's Fort Riley in Kansas.
Okay, and did it go to court?
No.
All right, and however it wrapped up, or anything you do know about the process, did you have an opinion about whether it was fair or unfair?
I think it was unfair.
Unfair, thank you. That's number 84, right? Okay. Anyone else that I missed? I'm looking for anyone that I missed at all. Oh, I see 46. You stand up and was it you or an immediate family member? And how long ago? 7 years. And city and state? St. Louis, Missouri. Did it go to court? And whatever the outcome was, did you believe it was fair? Okay, thank you. Anyone else that I've missed? Okay, thank you. Does everyone understand, and you can do this just by show of hands, does everyone understand that you'll be asked to consider only evidence that is presented to you in court if you're on the jury and not outside things? Does everyone understand that? Affirm that just by raising your numbers. I'm looking for anyone. Okay, and then if you'll put them down, does anyone disagree with that statement? Seeing no hands on that? Okay. Has anyone seen, and this is again just by showing your number, has anyone seen media coverage that included mentioning the defendant in this case, Dr. Ebony Parker, just by show of numbers? Okay, and you can put those down. That was quite a few numbers, but not everyone. And so I'm going to continue along that same line. Is there anyone here who would say you actively searched out information about this incident online, like you looked for it online in some way? If so, raise your hand up. All right, all I'm going to do right now is list your numbers, okay? So I'm not even going to ask you any questions, but the numbers that I see in the jury box, number 6, number 13, you can put your number down when I say it, number 25, see, 34, 36, 45, 49, 59, 58, 64, 65, 68, 80, 79, 78, 70, 69, 81, 83, and then I saw juror number 84 had a question. So number 84, you have a question about that? No, we can talk about it privately, so I'm just going to put a note that we can talk about it privately. 84 wishes to speak about something private. Okay, so similar question. Has anyone here had discussions, either commenting online or discussions offline, person to person, specifically about Dr. Ebony Parker? By show of numbers. Okay, again, what I'm going to do is list these numbers. So number 6, number 13, number 15, number 22, 25, 30, 36, 41, 43, 45, 47, 48, 49.
Okay, Ms. Jenkins, you're going a little bit too fast for me. I last marked at 43.
Can everyone raise your hand up?
Okay, no, okay.
Back to
45.
43.
Okay, 45, thank you, okay.
45, 47, 48, 49, 58, 59, 64, 65, 68, 61, 62, 69, 70, 78, 79, 80, 81, 82, and 83, and 84 wants to speak privately about this matter. Understood. All right. Same style of question, just by showing your number. Did anyone here watch on television or the internet any part of the actual civil trial related to this incident regarding Rich Neck Elementary School? Watch any part of the trial itself, okay? We'll list the numbers 6, 13, 15, 16, 22, 23, 30, 34, 41, 45, 47, 58, 59, 61, 62, 64, 65, 76, 79, 80, 81, and 83. Anyone on this? All right. Is there anyone here, based on that pre-existing knowledge, who has already formed an opinion about the guilt or innocence of Dr. Parker? Raise the numbers. I'm starting with the jury box. Any numbers? All right. Number 13, I'm not going to ask you what your opinion is about the guilt or innocence of Dr. Parker. But what I am going to ask is whether, if the court were to instruct you to be fair and follow the law, would you be capable of setting up an opinion aside and just making a decision based on the evidence you see? Is that yes? And your number again? 13. Thank you. Next, any others in the box? Okay. So number 15, would you be able to set aside a preconceived idea and still give a fair hearing to both sides in this case? Okay, thank you. Number 16, same question. Would you be able to set aside a preconceived idea and give a fair hearing to both sides in this case?
I've been studying law at Regent University, and I want to hear the details.
Okay, me too. I studied there as well. 22, you don't know, all right. 23, would you be able to set aside an opinion and give a fair trial to both sides? Okay, I see you're not.
She said yes, 23 said yes?
Yeah.
Okay, and thank you. And, I know it's custom to nod our heads, but Madam Court Reporter has to record audible verbal responses. Thank you.
I'm sorry, Your Honor. So, I believe 22 responded, is that
Yeah.
correct? And I guess there was, I didn't hear the response.
That's it, I don't know, honestly.
Don't know, okay.
Anyone else on this? 25, would you be able to set aside an opinion and still give a fair hearing to both sides?
I'm not sure.
All right, number 30, same question.
Yes.
Yes, you would, all right. Number 34, would you be able to set aside an opinion?
I'm not sure.
Okay, number 36, could you give a fair hearing to both sides?
Yes.
Okay. Number 41, would you be able to give a fair hearing to both sides? Okay, unsure. I heard from that one. 41. Number 45, would you be able to set aside your opinion and give a fair hearing to both sides? Okay, could you stand and speak a little louder so we can all hear?
I've tried, but I don't think it would be as easy for me to say I don't care.
Okay. And if the judge were to instruct you on the law and say, only consider the evidence and the law, would you be able to follow the instruction? Who else? 46. Would you be able to stand? Thank you so much. Number 46, would you be able to set aside a preconceived idea and just give a fair hearing to both sides? No? Okay. Number 47. Okay. Number 58, would you be able to give a fair hearing to both sides? Number 59, if instructed to just follow the law and give a fair hearing to both sides, would you be able to do that?
No.
Okay. Number 61, would you be able to give a fair-minded hearing to both sides? Okay. 62, would you be able to give a fair hearing to both sides? Okay. Number 64, would you be able to give a fair hearing to both sides? No, all right. Number 68, what about you? Okay. Number 69, if instructed to give a fair hearing to both sides, could you do that?
I believe I could try, but I'm not sure.
Okay. Number 79, I think I know the answer on yours, but you want to tell us you feel like you could not? Okay, thank you. Number 80? Okay. Going to the back row, would you be able to set aside a preconceived idea and just give a fair hearing?
Number
81? And I think your answer, number 81, is no? Okay. Number
Well,
80,
I'm sorry, her answer is
No.
you're not able, thank you very much.
number 82, would you be able to set aside a preconceived idea and just give a fair hearing to both parties?
I'm not sure.
Would you try?
Yes.
Okay. 83?
I don't believe so.
Okay. 83 says, I don't believe so. 84, you think you could? Okay. Is there anyone else on that question? At the end of this trial and every trial, the judge will give you jury instructions, which are the law that applies to this case. Is there anyone here who would say, I would not follow the jury instructions, I might just rely on the law that I think applies? Anyone here who would not follow the law as given by the judge? If so, raise your hand. Seeing no one on the, okay. Just by show of hands, does everyone accept that as a member of the jury, you're called upon to judge witness testimony and evidence using common sense and reason, just like you do in your everyday lives? And if you do understand that, thank you. And finally, this question, is there anyone here who would go through the jury process, and if you came to a belief in your mind that the defendant was guilty beyond a reasonable doubt, you would nevertheless find the defendant not guilty? In other words, you do believe the burden was met, but you would just find the defendant not guilty anyway. Raise your card if your answer to that is yes, I would find the defendant not guilty even if the burden was met. Thank you so much for your time. That's all. Thank you, Judge.
Thank you. All right. And let's see, we've gone about an hour, it's about 12:30, and we have to do the same process for the defense questions. But I'm assuming that maybe you want to take a lunch break. Okay. And going forward, subsequent days, because I know parking's going to be crazy, I'll try to have pizza and salad here for everybody. You're welcome to bring your lunch. But I don't have pizza and salad for 84 people. We're going to take a lunch break, and attorney, you think an hour and a half is enough time for them to get food, get back, and find adequate parking? And we'll come back at 2 p.m.
That's fine for the public.
Okay. And as you all know, there are a few restaurants on 23rd Street, and there's some fast food if you go across Chris Jefferson Avenue. That grocery store, Piggly Wiggly, has a hot deli in South Park, or go wherever you like for lunch. I will give the cautioning instructions during recesses. Please do not discuss this case. Do not research this case. Do not investigate this case in any manner or locations or people involved with yourselves or anyone else or with other jurors. You can talk about the weather. You can say, my day's going fine, but please do not discuss anything that's happening. And when you report back at, let me say it's 12:35, get down the elevator, get back up. Report back to the room at 1:55, by 1:55, and then we'll get everybody up by 2. But I'm gonna ask you when you come back about what you discussed, and please report to me any issues. And anything further from the attorneys before we break for lunch?
No, Your Honor.
Okay, all right. And Sheriff, we're going to recess, and what are your instructions for them?
All right, jurors, what we're gonna do, all jurors, everybody will go back over here in the courtroom, and we got deputies coming up to escort y'all up out of here. So just.
Not leave your numbers anyway. Keep your numbers. We're gonna start here first, then you guys, and then here. All right, let's start.
Let me start with this row here. Well, it doesn't really even matter. Just everybody in the jury box. Please stand for the jurors.
Hey, everybody, welcome. Thank you for watching. I'm going to leave the feed running. I'm going to put a lunch break screen up there. When that comes down, you'll know that they are back. I just got to make a little comment here. First of all, Sue, this is a criminal trial. This is Ebony Parker. She was the school principal in Newport News, Virginia, when a 6-year-old came into the school and shot his teacher, Abigail Zwerner. Now, we sat through the Abigail Zwerner trial. So now we are sitting through the Ebony Parker trial. She was school principal, and she's been charged with gross neglect of a child, because there was a lot of things that they knew about this child ahead of time that probably should have prompted them to take more action than she did. So we're going to hear about that during this trial. Now, Law and Crime and Court TV, they don't usually cover jury selection. This is actually a local channel, local news channel. So as long as they're going to stay live with this jury selection, I'll stay on the feed. But interesting that he asked, could they set aside their feelings about this case to give a fair trial, and a lot of them said no. And I'm like, ooh, that was it. I've never heard so many no's. Yeah. So are they going to, first the defense has to go, if they get a chance to do some questioning after lunch, and then the two lawyers or the two sides, because they each have a team, will get together with the judge, and they will pick the jury out of their 100 jurors that they are questioning. It sounds like quite a few of them have already been sort of released in the minds of the parties. They haven't done it officially, but there's been enough said that there's quite a few people that are not going to make that jury. But they usually start at one and go through to the higher numbers to pick the jurors. And I haven't heard a lot of the lower numbers being questioned or raising their hands. So, like 1, 2, 3, we only need 12 or 6. I don't know if they're going for 6 or 12 in this case. Probably 6. I'm thinking it's probably 6. So in any case, I don't think we're going to have any trouble getting a jury out of this 100 people pool. It's a pool, folks. All right, so I'm going to leave this running while they all have lunch, and then we'll be back for the rest of this. So if you have a question, I'm going to keep checking the chat for questions. Yes, tornado. Oh my God, last night I'm sitting here diamond painting, and like every now and then the wind would just, like somebody turned on a switch. The wind would pick up so bad, and it's crazy. It is just, hopefully, knock on wood, no tornadoes in my area today. Yesterday they were in the Nebraska area, which is a couple of states over. So we missed it yesterday. Hopefully we'll miss it today. That is Ebony Parker on the screen there. You might recognize her. I don't remember if she testified in the last trial or not. I can't remember. In any case, I will see you guys after they come back for lunch.
That's how I did too, but you can never be too safe in the house. Thank you.
But there's nothing that I'm aware of that's of evidentiary value on the property.
Let me just jump in and say that the actual scene has been, destroyed, right? It's been torn down. The property's been sold. The kennels, all of that are gone. So that's no longer in existence.
But our experts, in preparing for the first trial, did all kinds of forensic tests on the crime scene. A number of, we put in evidence that if somebody could be in the house and shots fired down at the dog kennel, never hear them. I mean, we proved that without any contradiction whatsoever. So the story that he was up at the house and they go, he had to have heard the shotgun and an AR. Not. We had an expert run test. Can't do that anymore. So the uncontradicted evidence is going to be, if he was in the house, he wouldn't have heard the shots. So, I mean, it's those kinds of things. And we've got measurements. I mean, very, very, very specific measurements on where everything was, which, by the way, SWED did not do. The night of the murders, as they processed, it may not be SWED, maybe local law enforcement, they didn't dust for fingerprints in the feed, not dust, they don't do that anymore, but they did not process the feed room for fingerprints. They didn't look for DNA. Is that our hair? Let's pick it up and get it tested. There was a bloody footprint right next to Paul's body. It was a Carlton County Sheriff's deputy's foot. I mean, I'm not a big CSI fan, but this looks to me like they violated every basic rule. And we had a witness testify to that. So they got a lot of explaining to do.
What do you think the odds are of Alex getting an acquittal in the retrial?
You, John Monk, are playing those internet betting sites too much. I have no idea what his chances
I'm not playing them at all.
Well, you ought to try.
What do you think the odds are?
We have no idea. I mean, we don't predict football, basketball, or trials.
Just following up on what Dick said about the failures. During the trial, you'll remember SLED explained how they do murder investigations, and they do, they draw an imaginary circle, and then imaginary circle that they drew here, Alec was in the middle of it. And he was in the middle of it from the night of the murders. And they knew that Alec left Moselle and went to his mother's house at Almeda, and then came back to Moselle and found his wife and son murdered brutally. And do you think for 1 minute that they should have gone to Moselle, Almeda, to see if there's anything of evidentiary value? Were there murder weapons at Almeda, which they want to intimate, during the trial? Oh, he parked over here, so he must have got rid of the guns over there. I mean, they had the opportunity to exclude Alec from that circle, but they didn't do it because they just failed so miserably in what their jobs were.
Let me say one other thing that brings to mind. As most of y'all know, I was a prosecutor for 12 years, and this is 40 years ago. If a body was found and they wanted to determine time of death, the coroner or a medical examiner would take an anal thermometer and get a core body temperature, then take a thermometer and get the ambient temperature. And in this case, alleged an hour and a half prior they'd been killed, sort of. The coroner showed up and he did something that just amazed me. He took his hand and he stuck it under Paul's armpit, and then that same hand stuck it under Maggie's armpit, and he could calculate the time of death based on that. I mean, that's what we're dealing with here, folks. Stuck his hand under the armpit? Really? And yet, then they said, oh, well, we know when Maggie stopped using her phone and Paul stopped using his phone, that's the time of death. They ignore the fact that cell phone service down there was spotty at best. A number of people testified there was no cell phone service. So simply because they weren't using their phone doesn't mean they were dead. I mean, this thing has more holes in it than Swiss cheese.
In your opinion, what ultimately got Alex convicted?
I think 2.5 weeks of that of widows and orphans and mentally disabled kids testifying, not that he stole their money, but how just maliciously he stole the money, how he lied to them. When they finished with that, They're not going to believe forensic evidence. They're not going to believe him. They're not going to believe anything because
Well,
he was so vilified.
And when he testified, the jury was programmed not to believe him by the clerk of court. And so, no matter what he said, I mean, he got on the stand to answer, questions about where he was and what he did that night. And we know now that, as a Supreme Court accurately described, she sought to undermine his credibility before he even testified. And understand, she's the second highest ranked court official in the trial. And she has closest contact with the jury, develops close relationships with them over 6 weeks. And, she is the one that they see more, she's the elected official. She summoned them all in. Her name's on the summons. Her name's on the check that they get to payment every week for serving on the jury. I mean, and this person is back there in the jury room telling them in so many words, don't believe Alec when he testifies. Don't believe the defense. Don't let them confuse you. All of that happened at the end of the trial, right before we put up our case. So that is one reason he got convicted, I promise you.
You mentioned new evidence. If you already addressed this, I apologize, but you mentioned new evidence that you're going to bring out. You mentioned DNA found on Maggie's fingernails. Is there other new evidence?
Well, let me say this. If there is, we tell you, you're going to, I know you're not doing this intentionally, but you'll be telling them. So I don't think we tell you. How about that?
Fair enough.
Maybe not unintentional, but never mind. Anything else?
Do you think that Becky's done this with other trials before down in Carlton County?
Well, you don't know, do you? That's why this lawsuit is so important, because it's going to allow us to peel the onion on her and what she's done on this case with the other people involved. Was she a lone wolf? Has she done it on other cases? But certainly, it was a despicable act, and the Supreme Court found it to be such. Anything else? Thank you very much for coming today.
probably some core cause strikes that we agree on.
What's that?
There are probably some core cause strikes that we agree on. Do you want to try to put a list together of those right now? See if we can be some core. Some that we might agree on. I don't know. Let me just run by them and see if we do agree.
What is it? You think you'll finish this on Thursday? Right. Yeah. I'm okay. Yeah, no, I think it's your call. Okay. I'm okay with thinking we're struggling. My opinion was that we don't think that we're gonna go with, I don't think Friday was an issue, but yeah. Whatever, yeah. Yeah, okay.
Whatever.
Yeah, we can do that, that's fine. Oh, yeah, absolutely. Yeah. She understands English. I mean, that's really Oh, okay, that's okay. Yeah, that's fine. Yeah. Yeah. Right. Yeah. Yeah, we'll do it. I don't know what you need. Follow the problem. Okay, yeah. That's what I'm doing. So that's the only ones you. So we had issues with all the.
I'm the one to take that on inside this business. So I think maybe yes, and maybe no. Answers to questions.
What about the former paralegal for your office?
Yes.
49.
I have it written on the other one.
Yes.
Oh, okay. That's fine.
So what about all the ones that have number one public research?
I think that too is a case by case. I wish that has been more.
Well, the ones that say the bond form is opinion, and then say they're unsure, there was quite a bit of those last, I think it was the last question.
Once they say they're unsure, I feel like we should ask more questions to see. The rest of them clearly stated.
No. Yeah.
And then I would agree.
So those that
Clearly
said,
stated.
the ones that said,
Yeah, so I'll start with the numbers.
I did it as you. Hold on a second. Is it 50? We already said it. Yeah, okay.
22.
Oh, yeah, I think that's the one, 22 now, but she the one that says that she can't judge people. Is that the one?
Yeah.
She also said.
Yeah.
25. She said. So she couldn't be there. Yeah. I told her.
They may have said like unsure. I have
Yeah,
unsure.
right, sure.
Oh, so we have both of those missed.
Mhm.
Is what it is.
So, very fourth out. Okay.
Well, all of them, well, if we're going unsure, then that's a lot more.
Yeah, that would be 1, 2.
I have 45 minutes.
15. Up to 15 that were either.
I have no for 58, but I think she's done. I have no for 58, no for 59.
Okay, so early numbers are 45, 46, 47, 58, 59. All those are numbers.
Okay, 45, 46, 47. As they tell me again.
47, 58, 59. After that, I have 68, 79.
Okay. Well, for 70, 79, 80, 79,
81,
83, 79. I think 83 is off as well.
Yes.
That all that.
Yeah.
So that's 40. you're looking multicolored screen with an F.
Okay, but they can't hear anything over that screen.
Correct.
Okay, understood, thank you. Okay. All right, but
Well,
everything, yes.
on that point, I believe that they could hear something.
Somebody was reporting to me that they could hear, it was a hot mic.
Well, there may have been something from the audio from your microphone transmitted to our receivers. Unless they're taking a feed elsewhere, it wouldn't go into any other place.
Okay, so I'm just, I guess, caution all parties in the courtroom, I don't know what, but they could hear, I think some of the bailiffs just procedurally moving around. The hot mic is here, but okay, yes, Ms. James, you want to take something up?
Just quickly, Judge, if you would like to take it up, defense counsel and I conferred, and we have a list of jurors that we already agree should be released for cause. And I think we agree that these could be released even before the defense continues their voir dire, if you would like to do that.
Okay, I have no objection to that, and that way we can release people. And then somebody said number 15 is not feeling well.
That is one of the ones.
Okay. Okay, so
Yes.
we'll release her first. Do we need to get medical attention for the children? Or
She said it was just difficult for her to breathe while in there, so, let's find out.
Okay, just bring just
Yeah.
number 15, if she's having breathing problems. And what are her instructions? All that.
Tuesday, May
After 26th, yeah. And good afternoon, ma'am. I just want to confirm you are juror number 15? Yes. Okay. It's my understanding you are having some breathing difficulties and some other medical issues. And I just want to say, we appreciate you coming down here today, but we are able to release you from serving on this jury. Okay, now, you're still on the panel. You need to call back next Tuesday, May 26th after 5 to see if you have to report for another jury. But for this week, you are excused.
I have thyroid eye disease. I take Tepazza infusion once every 3 weeks. And I have to take, I can't miss it. It's on the 26th.
Did you inform the jury coordinator?
No, not about the Tepazza. I was so busy.
Okay, please let the jury coordinator know that you have a medical appointment that you can't miss, regularly scheduled infusion, so she can excuse you. Okay, but just let Miss Knight know. Okay, Mary, yes, Mary Knight. Do you know who to let know?
Yes, it's Mary.
Yes, and you have that information in your juror information and when you call that number.
Yes.
But yes, just let them know and it won't be an issue. Okay, so you have your number and something dropped on the floor.
Stand up for me, okay. Yeah. All right, I have the number.
Okay, all right. And Sheriff, you'll escort her out of the building. Thank you very much.
No, thank you all for your service.
So the other numbers that we have agreed to, Judge, and I know defense counsel is double checking me. If I get one wrong, speak up. Number 11 indicated a religious holiday.
Okay.
Number 15's already been excused. Number 17 knows me from a prior case.
Okay, no objections to that. Okay, so all agreed upon. Okay, yes, go ahead.
Number 47 needed to be a caretaker for her father. Number 49, don't remember exactly why.
He's a former paralegal for
Thank you.
the Commerce Attorney's Office.
Paralegal for Hampton Commons Attorney's Office. Number 71 had indicated knowledge of Molly Newton. Number 79 indicated being friends with Ms. Werner. And number 83 knows another prosecutor in my office. And Judge, we've also agreed on the following people because they were adamant they could not be fair. And so those numbers are 45, 46, 47, 58, 59, 68, 79, 80, and 81. I think that's all.
And 83.
And 83.
Okay, let me go back over that to make sure I reported it accurately. I have 11, 15, 17, 47, 49, 71, 79, and 83 was in the first batch. Yes, okay. And then the second batch is 45, 46, 47, 58, 59, 68, 79, 80, and 81.
That is what I have.
Yes, sir.
Let me count total persons.
22. Oh, yes.
22 also? Oh, yes, we should have said 22 as well. I'm sorry.
Okay, let me add 22. So by your count, that's 18 people. Do we agree? Do we concur on the arithmetic?
We're coming with 16.
16.
You have 16? Okay, that's why I asked. Let me count again.
So I'm sorry. I have 18. And she has 18.
So let's some numbers. Oh, okay. 79 was in both lists. 79 and 47 are in both lists.
That's the discrepancy.
Oh, yeah.
So let me count again.
I would say I don't have this.
All right, so we're at 16 now, and I'm gonna read them chronologically, understanding that 15 has already been excused. 11, 15, 17, 22, 45, 46, 47, 49, 58, 59, 68, 71, 79, 80, 81, 83. Okay, and council's not in there to get an affirmative. Okay, so I'm gonna pass this to Bill to have him call them, those persons in, and we can excuse them. Those that agreed for cause. And again, 15, we already let 15 go.
Here you go. That's it. Oh, yeah.
18, and we need to have at least 24 to get to peremptory strikes.
Amazing. You don't have to go over the all present.
Thank you very much. All right, and I'm going to take attendance. So we'll start with the gentleman in the first row to the wall, my far right. And if you just read your numbers, so I want to make sure we have the right numbers in the courtroom, the right your numbers.
11.
Thank you.
17. 22. 45. 58. 59.
68.
46.
47. 49.
71.
80. 79. 83. 81.
Okay, thank you. And we are able to excuse you from this jury. Thank you for coming down today, and I appreciate your answers to the questions. And so, your instructions for further jury service during this term. You will need to call back next Tuesday, May 26th after 5 to see if you need to report for any other juries, but you are excused from juries this week. And the sheriff will indicate how they're going to collect your numbers and the way to come out the building. The sheriff at the door will take your numbers. And again, I appreciate your time. I know everybody has important and pressing things in their lives, but we cannot operate without you all and without your participation. And you have my sincerest appreciation. Thank you very much. You all are excused. One moment, just making sure my list is reconciled with where we are. Anything else before we comb the rest of the panel and resume Juanita?
No, I don't know how.
Okay, Sheriff, you bring in the rest of the panel. Thank you very much.
please stand for the jury. Oops, I'm sorry. Remember, there's some people missing. Sir? There you go. Ma'am. Hold on. You should be right. 6 people on there. There you go. Next bench. Take the bench behind there. No, ma'am. Yes. Take the next bench behind her. Ma'am. Right here. Should be 6 on there. Yeah. You can raise something one more. Oh, just like that. There you go. You may be seated. All jurors present.
And to the attorneys, we returned from lunch break, the jurors are here. Do you wish to have them, take attendance by number or just do a head count? I believe we should have 68 people.
We'll waive full hearing.
Okay, now I'm just gonna do a head count. So I have 14 in the jury box. And Chair, we have even rows of 6 until we get to the last row, is that correct?
That's 6 also.
Oh, that's 6 also, okay.
And that's.
Which means I should have 8 rows of 6.
It's not. 9.
9 rows of 6, okay.
9 rows of 6.
All right. All right, 9 times 6 is 54. 54 plus 14 is 68. And we started with 84. We excused 16, so we have the correct number. We have 68. Okay. And thank you all for returning. I hope you had an adequate chance to refresh yourselves. There was a cautionary instruction not to discuss the case, not to research the case, not to investigate, and if anyone approaches you, to tell them they cannot talk about the case. Does anybody wish to report an issue with those instructions? Okay, no issues being reported. We will turn it over to the defense. Mr. Rogers, Mr. T, do you all wish to propose any voir dire questions to the jury?
Yes, Your Honor.
Okay, you may proceed.
Thank you. Good afternoon, everyone. I'm Stephen Teague. I am co-counsel with Curtis Rogers on behalf of the defendant, Dr. Ebony Parker. I'm going to ask you some questions, and so please just raise your numbers if it applies to you. Are there any people here that are retired? So nobody in the jury box is retired? Okay. So we have 38, 29, 38, 18, 44. When I call your name, you can just put your name, your number down. 48, 63, 64, 19. Anyone else retired? 18, yes, I have. Thank you, sir. All right, for those who are retired, what job did you retire from? So let's start with 18.
I worked for the state of Delaware.
State of Delaware. All right, 19.
After my 62.
I'm sorry.
I started on Social Security after my 62.
Okay. What job did you retire from?
Well, I was working in different places, but I was a service-connected disabled veteran.
Okay.
Yeah.
Okay, thank you. All right, 29.
I retired from the military, from the Air Force, and I'm also retired from civil service.
Thank you. 38.
Retired as a Xerox technician.
Xerox technician. Thank you. Yeah. We next have 44. Thank you, ma'am. Auto injury claims adjuster. 48.
Welder.
Thank you, sir. 63. Surgical technologist. Thank you, ma'am. 64. Designer and Engineering Department in Newport News, Sheffield. Did I miss anyone? Okay, thank you. Besides juror number 29, did anyone else serve in the military? Let's start with the jury box. Number 2, thank you. Okay, let's go in order. 25, 23, 30, once 19. Once I call your number, you can put your number down. 36, thank you. 37, 51, 56, 57, and 7.
Okay, hold on, Mr. T. Hold on.
Oh, I'm sorry. Oh, sorry.
Okay, 51, and after 51 was number 56,
56,
and then 57.
57, and 7.
All right, thank you.
Is anyone here related to anyone in law enforcement? So let's start with the jury box. No one there? All right. Let's start with, if you could just put your numbers up, okay? Put your numbers up, hold them up, please. Let's start with number 34. It's okay, you can, if it's someone in your immediate family, please let us know that. But other than that, just tell us yes or no.
My cousin is.
Okay, 34.
Not here.
Thank you. Oh, I'm sorry.
In a different state.
In a different state, thank you. 38. Okay. 54.
My son, last work.
Thank you. 62.
My cousin here.
All right. And 63. Thank you. And 76.
Cousin here.
Thank you. Does anyone have friends in law enforcement? All right, let's start with jury box 16. Thank you. 3.
I don't know if it counts, but nuclear security.
Okay, thank you. 9.
I'm not sure, but I have an uncle that is a lawyer in Illinois.
Okay, thank you.
One,
Friends, Hampton, Roads Police.
thank you. 24, Newport News. 30,
Several on Newport News Police Department. And some in the sheriff's department.
all right, thank you. 34,
Brand, sheriff's department.
here.
Yeah.
41,
It's friends here, one for news, one Middlesex, and one Fredericksburg.
thank you. 62,
Friend.
all right, thank you. 65,
Friday, Hampton.
thank you. 75, 74, I'm sorry.
Does it count if they're a judge? I know them by association.
What city?
Here.
Okay, Newport News, okay. And Circuit Court of GBC.
Circuit Court.
All right, 75, thank you. Oh, sorry, 50. 50. In Newport News,
Yes.
Circuit Court or General District Court? 70.
Dylan, not sure where.
Okay, thank you. Anyone else that I missed? 73.
Both retired judges from Newport News. I went to school with their kids.
Okay, thank you. Does anyone have any friends or family members in the Commonwealth's Attorney's Office? That's the prosecutor's office in Virginia. Any prosecutors offices in the cities in Virginia, period.
I think my professor was a prosecutor in Chesapeake.
Okay, your juror number
16.
16, thank you. Anyone else? Does anyone here work in the field of education? Okay. Number 8. What, are you in Newport News?
Yes, teacher.
Thank you. Number 20,
Teacher in Newport News.
51,
Teacher sub.
78,
I'm former Newport News public school teacher. Outside.
can you repeat that last?
Sure, now I work at Queen Rainsford.
Okay, thank you.
But former teacher.
It's 84,
I'm a behavioral therapist, but we sometimes do in-school therapy as well.
okay, thank you. 70,
Okay, and sorry, keep it staying, please. Madam Court Reporter wasn't able to hear your response. Give me your number again.
7.
Thank you.
Product trainer at Newport Leadership Building, the front school.
okay, thank you. Is anyone here related to anyone that works in the field of education? All right, 16, 13, 10, 9, 1, 20, 33, 34, 32, 38, 42, 61, 57, 65, 69, 74, 75, and 76. Thank you.
And of those who just raised their numbers, how many of those family members are work in Newport News?
Not public,
Okay,
Newport News private.
okay. All right, so 16, 10, 13, 69, and 76. 61, 42,
I'm not sure.
38, 32, 74.
I'm also not sure.
Okay, thank you. Now, does anyone have friends that work in the field of education? All right, 16, 10, 13, 12, 5, 7, 20, 33, 34, 36, 41, 51, 52, 57, 67, 69, 70, 75, 76, 78. And of those who just raised their numbers, do your friends work in Newport News? If they do, raise your number. 16, 12, 13, 10, 5, 34, 36, 57, 70, 67, 69, 76, 78. Thank you. Do you know anyone that works for Newport News Public Schools? $16, 14, 13, 10, 5, 3, 19, 20, 23, 30, 34, 32, 36, 41, 42, 50, 55, 61, 62, 63, 57, 64, 69, 70, 67, 65, 73, 75, 76, 77, 78. Thank you. Has anyone here been the victim of a crime? Okay, juror number 9, juror number 2, 34. That it, 84. Did I miss anyone? 9, 2, 34, 84. Okay, thank you. Has anyone here been the victim of a crime involving a juvenile? No? Okay. Has anyone here been the victim of a crime? Oh, I'm sorry.
It was years ago when I was growing up.
When you were a juvenile? And it involved the juvenile as well?
Yeah.
Okay. Thank you.
And that's number juror 34 for the record.
Has anyone here been the victim of a crime involving a firearm?
Personally or a family member?
You, yourself.
Who's
I'm
speaking? Raise your number, please, and stand up.
Victim. Yes, a victim. Now, for the next question. Does anyone here have a family member or a friend that has been the victim of a crime involving a juvenile with a firearm? Does anyone here, or has anyone here, or does anyone here have a family member or a friend that's been the victim of a crime involving a juvenile with a firearm.
Okay, stand up, please, for
34.
34 and 75. Starting with your number 34.
Yeah, my ex-roommate, his son was murdered. 2 of them actually.
Okay, by a juvenile with a firearm.
Yeah.
Thank you. 75. Thank you. Has anyone here been involved in a case that involved abuse or neglect of a child? Okay, number 9. 36. 70. Anyone else? Does anyone here have a family member or a friend that has been involved in a case involving abuse or neglect of a child? A family member or a friend that has been involved in a case involving involving abuse or neglect of a child?
All right, hold on, wait, okay, we have 16 in the box.
Oh, I'm sorry, 16, thank you. 73,
We were granted custody of a child due to substance.
thank you. 36,
I'm a pediatrician, so I dealt with a lot of cases
Thank
with
you.
veterans as well.
yes, thank you. 38,
A cousin.
cousin, thank you.
Did you get?
And you have 2 more responses.
Oh, I'm sorry.
And yes.
Number 3. Thank you. 43. Thank you. 62. Thank you. Anyone else? Thank you. Is anyone here in the medical field? All right. 6, 13, 36, 39, 60, 67, 72.
Can I ask a question?
Yes.
I'm retired.
Yes, that accounts. So 63, 76, 23.
I'm sorry, question, does the mental health book count?
We'll count 84. Did I miss anyone? I got 6. Yes. All right. Is anyone here a supervisor in their chosen field? Okay, let's start in the jury box. 5, 14, 10, 21, 28, 29, 34, 36, 35, 41, 50, 48, 60, 62, 70, 82. Anyone else, a supervisor in their chosen field? Is anyone here an investigator in their chosen field? 36, investigator.
Does that mean like any type of investigator?
Any type of investigator. 36, 41, 44. Anyone else? Thank you. Would any of you convict a person of a crime based on mere suspicion of having committed some crime, even if you are instructed that mere suspicion is not enough. Let me ask that again. Would any of you convict a person of a crime based on mere suspicion of having committed some crime, even if you were instructed by the judge that mere suspicion is not enough? Okay. Would any of you convict a person of a crime even though you have not been convinced that a person committed the crime beyond a reasonable doubt? Are any of you familiar with the special grand jury report regarding the shooting at Rich Neck Elementary School? Are any of you familiar with the special grand jury report regarding the shooting at Rich Neck Elementary School? 25, did I see you?
You got some of the panel first.
Oh, I'm sorry, 16, 13, 25?
No.
Okay. Ma'am?
What do you mean by that?
There was a special grand jury report that was released to the public. Are you familiar with that? No? Okay. 6. Were you familiar with the special grand jury report? Okay. Of those who are familiar with that report, are you familiar with the conclusions that were arrived at in that report? Okay. Anyone else?
Yes.
Okay, and that's number 25.
25. Have any of you seen any press conferences regarding the special grand jury report regarding the shooting at Rich Neck Elementary School? Okay, let's start 16, 25, 30,
Okay, hold on, Mr. T.
16, 25, 30, 36.
Thank you.
You have a number in the back.
69. Special grand jury report that was released to the public, and if so, were you familiar with? Did you also see a press conference related to it? So 69.
69, thank you.
Thank you. She said something. Have any of you seen or read any media stories regarding the shooting at Rich Neck Elementary School? Okay. All right. So 16, 6, 5, 10, 13, 12, 7, 8, 3, 2, 1, 20, 21, 23, 24, 25, 26, 27, 30, 34, 36, 37, 38, 41, 42, 43, 44, 48, 51, 53, 57, 61, 64, 62, 69, 65, sorry, 70, 67, 73, 76, 78, 82, 84.
Mr. Teague and Judge, I thought I saw a number go up in the bench and back down that you didn't say.
Okay.
I just want to see if you want to confirm, ma'am, on the very.
Yeah, I didn't see anything.
Oh, I see. Okay. I thought I'd seen it raised. Thank you.
All right. Have any of you had discussions with family or friends regarding the shooting at Richneck Elementary School? Okay. All right, 6, 16, 5, 10, 3, 13, 2, 7, 8, 1, 20, 23, 24, 25, 26, 27, 30, 34, 36, 37, 38, 41, 43, 42, 48, 61, 62, 64, 65, 69, 76, 78, 82, 84. All right. Of those people who've spoken with family or friends regarding the shooting at Richneck Elementary School, did those discussions with family or friends convince you that Dr. Parker was guilty of a crime? Do you understand that right now, Dr. Parker stands before you as a person that is presumed to be innocent? Does anyone not understand that? Okay. Do you understand that before you can convict Dr. Parker of any crime, you must be convinced that the Commonwealth has proven its case beyond a reasonable doubt? Does anyone not understand that? Okay. Are you all able to suspend judgment, withhold judgment until you hear all the evidence?
Yes.
Is anyone unable to withhold judgment until they've heard all the evidence? Are you all committed to making sure that Dr. Parker gets a fair trial?
Yes.
Is anyone not committed to making sure that Dr. Parker receives a fair trial? Okay. Do any of you here feel that you are more of a follower than a leader? Okay. Is there anyone here that has a hard time standing up to strong personalities? Okay. All right. Nobody in the jury box. Okay. 26, 27, 32, all right, 69, 82. Anyone else have a hard time standing up to strong personalities? Okay. Is there anyone here that believes that we must accept that a majority of people must know what is right, even though you may have come up with a different conclusion of your own based upon the clear evidence? Yes. Is there anyone here that believes that you must accept that a majority of people must know what is right, even though you may have come up with a different conclusion based on the evidence? In other words, are you able to, exactly, are you able to, if in the face of a majority of people who believe something differently than you, are you able to come to a different conclusion based on the evidence presented to you?
Right, there's a number.
Oh, I'm sorry.
Somebody held it there.
Oh, thank you. Is there anyone here that will go along with the majority, even though they strongly believe that the majority of people have reached the wrong conclusion based upon the clear evidence? Are you able to make an independent determination of whether the evidence establishes guilt beyond a reasonable doubt? Are you willing to stand against the crowd if you are convinced that the evidence has not established beyond a reasonable doubt that Dr. Parker is guilty of a crime and find that Dr. Parker is not guilty? Okay. Your Honor, those are the questions I have for the full panel. We may have some follow-up that we might want to do with individual jurors.
Okay, and yes, some jurors did indicate that they wish to answer privately, and we marked those, so we'll do so now. So here's the procedure going forward. Myself, along with Madam Clerk, Madam Court Reporter, and counsel will retire to the room back here. And then the bailiff will call you all by your jury numbers to come and answer the questions privately. While we're doing that, this courtroom, the formal courtroom, will not be in session because we're moving back there for the private part of this proceeding. So we'll ask the news to stop recording once I step off the bench. And in the meantime, it's been about an hour since you've been back to lunch. So the sheriff can also have other people use the restroom and take a break or need to get some water while we're taking up the private questions. So that's the process going forward. And anything else from the attorney before we retire to that room?
No, Your Honor.
No, Your Honor.
Okay, all right. And everybody can keep their seats and I'll meet you all back in that room and then we'll call the numbers. Thank you.
I know.
There's John. Hey, Mr. Welcome back. Hey, John. Good to see you. I made it back alive. I thought I saw Wolf folks. Well, see you, buddy. Any of the old faces here? Okay. Couple things. We have filed a lawsuit today. We're going to discuss that with you in just a minute. I'd hoped that would have been the main topic of this lawsuit today. We're going to discuss that with you in just a minute. I'd hoped that would have been the main topic of this press conference, but over the weekend we learned that the Attorney General has announced he's considering the death penalty in this case. Clearly, he is not talking to the lawyers in his office. He's probably talking to his political consultants who thought that was a good soundbite for his governor's campaign. The law is clear that he cannot seek the death penalty if it is due to vindictive prosecution. That is, and here's the question: what does he know today he didn't know 5 years ago? Why is he saying he's going to seek the death penalty? Is there some new piece of evidence? So we're a little sick and tired, and we've seen this process since the beginning of this case, where Alan Wilson plays politics as opposed to playing prosecutor. He's got great lawyers on his staff. He should listen to them, defer to their judgment. Coincidentally, he has not looked into the attempted jury tampering of Becky Hill. We're going to talk about a civil suit in a minute, but clearly the statute says whoever tampers with a jury or attempts to tamper with a jury is guilty of a crime. Judge Toll's fact findings were clear. Becky Hill attempted. The Supreme Court last week, Becky Hill attempted. So please, Alan, focus on your job and not the politics. Now, having gotten that out of my system, let me turn this over to Jim Griffin, who's going to talk about the lawsuit that was filed this morning, and then Phil Barber and he and I will answer questions. Jim? Yeah, good morning. Today in United States District Court, federal court, the Charleston Division, we filed a lawsuit on behalf of Richard Alexander Murdoch Sr. versus Rebecca Hill. In this lawsuit, we file it under the Federal Civil Rights Statute, 42 United States Code 1983, to redress constitutional deprivation of rights. Those rights were Alex's right to a fair trial, a right that him be tried before an untampered, untainted jury. With the South Carolina Supreme Court's ruling, it has been adjudged as a matter of state law that she deprived Alex of his constitutional rights, deprived him of a right to a fair trial, and as a result, we've got to do it all over again, which nobody wants to do. The damages that we've alleged include the over $600,000 that was spent to try the first case and other compensatory damages. Now, let me be clear. Alec Murdoch owes a lot of people a lot of money. None of this money that is recovered will go to him personally. And the purpose of this lawsuit is to hold Becky Hill accountable for what she did. She has not been held account at all for her conduct. And two is to investigate exactly what she did, which we'll be able to do through the course of civil litigation. We have subpoena power. We can take depositions. And so we're going to be able to understand the entire scope of her conduct. She's yet to be thoroughly investigated by the state, and she's not been held accountable by the state. And that's what we hope to do. That's what we intend to do. And that's what we will do with this lawsuit. Thank you. Bill, what you got?
I would just amplify that and say that, you know, the jury process, the integrity of the jury process was violated by somebody sworn to uphold it. That's why we're here today, and that cannot go unanswered, as Jim said. And that's what we're going to do with this lawsuit. Beyond that, we've alleged $600,000 In damages, that's a public number, by the way. There was a receivership. That money was allocated from receivership for the defense. That was a waste because of what Becky Hill did, plus other damages alleged. And beyond that, we are going to find out exactly what happened. There will be depositions, there will be subpoenas, and she will be held to account for her actions.
Any questions? None? Okay.
Do you guys have any new evidence to present to your case?
Well, we have, we have received a number of pieces of information post-trial. Some of them came just to us. Some of that came just to us. Some of that went to SLED too. And we don't know what they did with it. Once the trial was over, we don't have the power to subpoena. We don't have the power to really investigate it all. All we did was, after the trial, was look into the jury misconduct. And we rode around Carlton County for a couple months through the swamp on the dirt roads to find these jurors and ask them questions. But once a judge is appointed, and I think we got an order on Friday that the Chief Justice has said, once the remitter is issued, which means right now the Supreme Court has the case, they got to remit it to a trial court, and he'll do that, we think, in the next couple of weeks. So at that point, then we will have subpoena. Then we will have the ability to investigate.
With the new murder trial, how hard do you think it is going to be to find impartial jurors?
Well, let me say this to you. This has gotten extraordinary notoriety, unlike most other cases I've ever tried. But in its time, the case I prosecuted 40 years ago, Pee Wee Gaskins, Monk was there. Pee Wee Gaskins, we had to go through 400 jurors to get 14. It's important that we have, what we want is individual voir dire. That means we individually question the jurors, which is not usually allowed in anything but a death penalty case. So we think we can get them. Now, can we get it in Carlton County? That's debatable, but and I think the state has the same interest, should have the same interest we have in finding a 12 or 14 with alternates, impartial, fair jurors. The state should want an unsullied, uninfluenced jury as much as we do.
And have you talked to Alec recently? How does he feel about the overturn?
Jim talked to him this morning.
Yeah, we've talked to Alec a lot lately about many topics, including retrial and what that might look like. But to your specific question, frankly, when we reported back to him after our argument in the South Carolina Supreme Court, we told him it went as well as we could have hoped, and that we were very optimistic that we would get a favorable result. And he appreciated our assessment, but he was incredulous. His experience has been, since he has been on the back end of civil lawsuits and criminal indictments, that he's lost every significant legal ruling along the way. And that occurred almost daily during the trial. And when he got the order, when I spoke with him, he had already read the opinion of the Supreme Court, and he says, I'm reading it, I see it, it says reverse, but I still have a hard time believing it. It's really just sinking in. But he was very grateful, very thankful, and he thanked all of us here that are on this side of the podium. And he got somewhat emotional. He was so, and I don't think he'll mind for me telling you this. I mean, he has always said, and he told me very early, that he deserves to be in jail, prison for the financial crimes that he committed. But he says, being in jail for something you didn't do is a hard thing to swallow, even though I'm here doing time for what I did do. But then he said, what I was convicted of is so reprehensible. It's something that is so heinous, and to be wrongfully convicted of that is almost unbearable, he says. And so he is very thankful that he is no longer a convicted murderer of his wife and son, and he's appreciative to the court for applying the rule of law, regardless of outcome. They did their job, and we're all very appreciative of that. The rule of law won out last week.
Have you spoken to Buster, and how does he feel about what happened last week?
So yeah, I think thanks for asking that question. And I want to say this: Buster Murdoch is, hopefully we can all agree, is entitled to his privacy. That kid has been through so much, and that's all he wants is his privacy. So we're not going to answer questions about Buster, other than to say, and I'd say it with 100% confidence, that Buster supports his dad, Alan.
With the civil suit, are you hoping to get your hands on this one investigation into the jury tampering allegations by the female?
Sure. Now, we were given some information through the discovery during the motion for new trial stage. Is that all they've done? I mean, we don't know. But if that is all they've done, that really wasn't much of an investigation. And we really don't think they've done much of an investigation, but we certainly plan to.
And let me say this. This also was a Freedom of Information Act served on SWED to get additional information. We've seen that too. Does it make sense to have the agency who has an inherent conflict, they want the conviction sustained, investigating whether it was valid or not? I mean, it just seems ridiculous. And again, I think the Attorney General's fault is not asking for some independent. He could have gotten a sheriff's department to it. Leon Lott folks, or the sheriff up in not Spartanburg, Greenville, have a very sophisticated sheriff's department. Charleston also. Use them. But SWED is invested in affirming the conviction. They don't want to find any fault. I mean, that's just human nature. So we think there's going to be plenty of things that weren't looked into, and we want to look into those. And the question is, and Jim and Phil and I have been talking about this, did she do it alone? Did she have somebody help her with this? And if you were sitting in the judge's chambers like we were, when she brought in information on the jury you would call the egg lady, we call Myra Crosby, and listen to what she had to say. One time it was totally made up about some Facebook page. The second time, inexplicably a anonymous email came to the judge. We weren't told about it. It was investigated by the Attorney General's office and SWED without us being involved. No guardrails on that. But I mean, and call us naive because we were. We didn't press that. And I look back on it. We should have, 2020 hindsight, we maybe should have taken a little more aggressive. But we still couldn't deal with that on your back then. But we will now.
A question about the retrial. Some have suggested that it may have been a mistake to put Alec on the stand. Any thoughts on whether you're going to put him on the stand in the retrial?
Two things. One, the client makes that decision. Two, that'll be a game day call. So you'll know when we know.
When will any retrial take place?
I would suspect within a year of now, but not by the end of the year. No, hell no.
And why is that? Why can't you go right to
Well, I'll give you a couple of simple examples. One, we assume the same witnesses will testify in the retrial as the trial. We have a, 8,000 page transcript. We've got to break out each witness. We've got to read it, whoever's going to handle that person, outline it, and they can be used to impeach them. So unlike, this is like a civil case where you've taken a deposition. Unlike any other criminal case you'll ever defend or prosecute. So that takes time. We've got to go back and see if they've given us all the discovery. There's some inference that we didn't get everything from the prosecution. We're going to go back and scrub that real hard. We've got to hire experts. They've got to look at all the information, new experts, and then give us an opinion.
Do you have enough money to hire new experts?
Jim, why don't you explain financially how this works? I think he's got a much better explanation for this than I do. Go ahead.
I mean, there is no new money, no found money. And I've said previously, we got paid do a job, and we do criminal defense work. And one way you do, you charge by the job. Sometimes you come out ahead, and sometimes you come out behind. But right now we're in the hole, but we got paid to do a job, and we're going to see it all the way through.
You're saying the job isn't finished yet?
Job is not finished yet. We're not walking away from it, so we're going to see it through. That's where we are.
Is there any chance a retrial could happen in Richland County instead of Palisades?
One of the things that we're looking at is a motion to transfer venue to a different county. It would have to be, if that takes place and is transferred, it'd have to be in a county that has a very similar demographics as Colleton County. So that would probably exclude Richland County, Charleston County, which I know all of y'all want to go to Charleston.
But Charleston is contiguous to Colleton, and one of the factors to be considered. Just saying.
And so, it's not our pick, but that'll be looked at very closely for sure.
Jen, can we talk about new evidence? I know last week you mentioned DNA evidence under Matthew's fingernails, essentially
right
connected to a male. Can we go into that a little bit more and how that will play a factor in this retrial?
Well, we pointed out during the last trial that they did find a unknown male DNA who was not related to any Murdoch or any of Maggie's family under the fingernail. That was, not really followed up on. We asked that they follow up on that before the last trial. We don't have possession of that DNA, so we can't do anything with it. We can perhaps, with a new case, back to square one, go and seek an order from the court to compel them to send it off to CODIS. CODIS is the national DNA database. If we were in charge and we had the facilities, the forensic lab, they had SLED, and we had search warrant abilities, we would have done things a lot different and more timely. A lot of that opportunity is lost, and so that's unfortunate.
More optimism of getting that sent to CODIS. Do you believe this go around?
Well, it will be. Chief Justice Kittredge issued an order last week saying he's going to appoint a new judge once the remitter goes down. And that'll be one of the things that we will present to a new judge asking for that relief. Whether he or she will do it remains to be seen.
Jim, you said the lawsuit is about holding Becky Hill accountable and also investigating. You say the state didn't do a good enough job of investigating her. What do you hope that investigation could yield?
The truth.
Yeah.
How about that?
Yeah, we don't have a result in mind, but we have a lot of questions that we would like answered. Was she a lone wolf? Was she doing it just for the, siren of celebrity, which she definitely was? And then I'll tell you, this removal of the egg lady juror is very suspicious, and that really wasn't a part of the case. We do make it a part of our complaint. We point out all of the inconsistencies of what she said, according to Judge Newman, that the egg lady, Ms. Crosby's ex-husband, had posted something on Facebook, which we now know was a bald-faced lie, or someone lied to her. I mean, it makes no sense. And if you have questions, and I would encourage all of you to follow up with Joe McCullough, who represents Myra Crosby, who is investigating this as strenuously as we intend to do so. And he's been working on it for quite some time. I mean, the way she was targeted, it just is very curious, and we hope to get to the bottom of that.
Is there any possibility of taking a plea deal for a lesser charge?
Say again?
Is there any possibility of taking a plea deal for a lesser charge?
No plea deal. No, never will plead guilty. Off the table. We want a trial. Yeah. They can dismiss it.
Yeah, they can dismiss these charges. But he'll never enter into a plea which requires some admission that he did something he didn't do, and that's murdering his wife and son. That's not going to happen.
Who do you think did kill Maggie and Paul?
We wish we knew. We think we could have found out if we were had the tools available. I mean, that opportunity was lost when they failed to follow the tire tracks in the grass leading away from the murders of Maggie and Paul. That opportunity was lost when they failed to maintain the integrity of the GPS data on Maggie's phone. Instead, it was at SLED downloading GPS coordinates at SLED that ultimately overwrote where her phone was and when it was on the night of the murders. And when they finally get into Maggie's phone and able to access the GPS data, you know where it said that phone had been last? Broad River Road, SLED Lab. I mean, that is outrageous that was allowed to happen. So, you know, John, we've gotten a lot of information. People are out there working on behalf of Alec for free, kind of like we are, and they've unearthed some really interesting stuff. And they've turned a significant amount over that to SLED. We'll be curious to see if SLED has done anything with it or will do anything with it.
If any of that investigation now goes back to the house or to the property, or is that?
There's nothing that I'm aware of that's of evidentiary value on the property.
Let me just jump in and say that the actual scene has been destroyed, right? It's been torn down, the property's been sold, the kennels, all of that are gone. So that's no longer in existence.
But our experts, in preparing for the first trial, did all kinds of forensic tests on the crime scene. We put in evidence that if somebody could be in the house and shots fired down at the dog kennel, never hear them. I mean, we proved that without any contradiction whatsoever. So the story that he was up at the house and he had to heard the shotgun and the AR, not. We had an expert run tests. Can't do that anymore. So the uncontradicted evidence is going to be if he was in the house, he wouldn't have heard the shots. So I mean, it's those kinds of things. And we've got measurements. I mean, very, very, very specific measurements on where everything was, which, by the way, SLED did not do. You know, the night of the murder, as they processed, it may not be SLED, maybe local law enforcement, they didn't dust for fingerprints in the feed, not dust, they don't do that anymore, but they did not process the feed room for fingerprints. They didn't look for DNA. Is there a hair? Let's pick it up and get it tested. There was a bloody footprint right next to Paul's body. It was a Carlton County Sheriff's deputy's foot. I mean, I'm not a big CSI fan, but this looked to me like they violated every basic rule. We had a witness testify to that. So they got a lot of explaining to do.
What do you think the odds are of Alex getting an acquittal in the retrial?
You, John Monk, are playing those internet betting sites too much. I have no idea what it's.
I'm not playing them at all.
Well, you ought to try.
What do you think the odds are?
We have no idea. I mean, we don't predict football, basketball, or trials.
Just following up on what Dick said about the failures. During the trial, you'll remember SLED explained how they do murder investigations, and they do, they draw an imaginary circle, and the imaginary circle that they drew here, Alec was in the middle of it, and he was in the middle of it from the night of the murders, and they knew that Alec left Moselle and went to his mother's house at Almeda, and then came back to Moselle and found his wife and son murdered brutally. And do you think for 1 minute that they should have gone to Almeda, to see if there's anything of evidentiary value? Were there murder weapons at Almeda, which they want to intimate, during the trial? Oh, he parked over here, so he must have got rid of the guns over there. I mean, they had the opportunity to exclude Alec from that circle, but they didn't do it because they just failed so miserably in what their jobs were.
Let me say one other thing that brings to mind. As most of y'all know, I was a prosecutor for 12 years, and this is 40 years ago. If a body was found and they wanted to determine time of death, the coroner or medical examiner would take an anal thermometer and get a core body temperature, then take a thermometer and get the ambient temperature. And in this case, alleged hour and a half prior to they'd been killed, sort of. The coroner showed up and he did something just amazed me. He took his hand and he stuck it under Paul's armpit, and then that same hand took it under stuck it under Maggie's armpit, and he could calculate the time of death based on that. I mean, that's what we're dealing with here, folks. Stuck his hand under the armpit, really? And yet, then they said, "Oh, well, we know when Maggie stopped using her phone and Paul stopped using his phone, that's the time of death." They ignore the fact that cell phone service down there was spotty at best. A number of people testified there was no cell phone service. So simply because they weren't using their phone doesn't mean they were dead. I mean, this thing has more holes in it than Swiss cheese.
In your opinion, what ultimately got Alex convicted?
I think 2.5 weeks of that of widows and orphans and mentally disabled kids testifying, not that he stole their money, but how just maliciously he stole the money, how he lied to them. I mean, when they finish with that, they're not going to believe forensic evidence. They're not going to believe him. They're not going to believe anything because he was so vilified.
And when he testified, the jury was programmed not to believe him by the clerk of court. And so, no matter what he said, I mean, he got on the stand to answer, questions about where he was and what he did that night. And we know now that, as a Supreme Court accurately described, she sought to undermine his credibility before he even testified it. Understand, she's the second highest ranked court official in the trial. And she has closest contact with the jury, develops close relationships with them over 6 weeks. And, she is the one that they see more, she's the elected official. She summoned them all in. Her name's on the summons. Her name's on the check that they get to payment every week for serving on the jury. I mean, and this person is back there in the jury room telling them in so many words, don't believe Alec when he testifies. Don't believe the defense. Don't let them confuse you. All of that happened at the end of the trial, right before we put up our case. So that is one reason he got convicted, I promise.
You mentioned new evidence. If you already addressed this, I apologize, but you mentioned new evidence that you're going to bring out. You mentioned DNA found under Maggie's fingernail. Is there other new evidence?
Well, let me say this. If there is, we tell you, you're going to, I know you're not doing this intentionally, but you'll be telling them. So I don't think we tell you. How about that?
Fair enough.
Maybe not unintentionally. Anything else?
Do you think that they could done this with other trials before down in Colleton County? How many?
Well, you don't know, do you? That's why this lawsuit is so important, because it's going to allow us to peel the onion on her and what she's done on this case with other people involved. Was she a lone wolf? Has she done it on other cases? But certainly, it was a despicable act, and the Supreme Court found it to be such. Anything else? Thank you very much for coming today.
That's that.
evening, everybody. Welcome to Courtroom Insider. It is Monday, May 11th. I'm Nate Eaton. Thank you for being here tonight. It is so good to be back. Took a couple weeks off. I'm working on some projects that you'll hear about very soon. So excited to tell you about those here shortly in the coming weeks. And just, getting caught up on everything. But I knew I had to come on tonight because we have a busy week happening here at Courtroom Insider, but also with cases that are happening across the country. And I'm going to, that's a little bit about what I'm going to talk about tonight. A couple of cases, 5 cases that I'm keeping an eye on that I think you're going to be interested in as the next few months come and go. And ones that have definitely piqued my interest, including one that I just heard about a few weeks ago. I don't know where I was when, I know where I was when the case broke out. I was covering Lori Vallow Daybell, so I wasn't really focused on anything else, but I posted about it earlier on my Facebook page, and boy, the response from many of you was fascinating. I think it's going to be a case that will have all of our eyes, and I plan to cover it. But how are you doing? It's good to be back with you. Hope you had a good Mother's Day weekend. Hope you had a good weekend in general, and would love to know where you're watching from and if you have any questions for me. And we can plan on Courtroom Insiders every night this week, because tomorrow morning